The empty waistband. In abiding dissent, Justice Sotomayor takes aim at the lie that lets police officers shoot unarmed men with impunity. On the night of October 30, 2010, Houston police officer Chris Thompson shot Ricardo Salazar Lemon in the back, severing his spine and paralyzing him from the waist down. Why? Each man's account of the encounter is dramatically different. Salazar Lemon claims he was simply attempting to walk away from the officer. Thompson says he thought that Salazar Lemon was reaching for a gun in his waistband. In fact, Salazar Lemon didn't have a gun. But when he sued Thompson for using excessive force against him, the district court chose to believe Thompson, throwing out the lawsuit. An appeals court affirmed that ruling, holding that Thompson's decision to shoot Salazar Lemon in the back was not unreasonable because he did it to protect himself. The Supreme Court refused to review the appeals court's judgment on Monday, effectively ending Salazar Lemon's quest for restitution. But Justice Sonia Sotomayor didn't let the case fizzle out quietly. Instead, she penned a powerful dissent, joined by Justice Ruth Bader Ginsburg, sharply criticizing her colleague's willingness to ignore a possible instance of police brutality. Sotomayor has been sounding this alarm for years, but her opinion on Monday is especially trenchant. It serves as a warning to us all that the court's excessive force jurisprudence has gone lethally off track, especially when the victims are minority men. Salazar Lemon v. City of Houston, like many police brutality cases, revolves around one question: did Thompson act reasonably when he discharged his firearm that night in 2010? The events leading up to that bloody moment, as described in Salazar Lemon's petition to the Supreme Court, provide some context. Thompson first spotted Salazar Lemon driving his truck down the highway at about 10 miles over the speed limit. He was accompanied by 3 friends, with his wife and children waiting at home. Thompson pulled him over, approached the truck, and asked to see Salazar Lemon's license and insurance card. Salazar Lemon responded, of course, and asked whether he could get out to retrieve his insurance information from his glove compartment. Of course, Thompson responded. The 3 friends sat quietly in the truck. When Salazar Lemon handed Thompson his driver's license, which is Mexican, Thompson said, "What's this?" Salazar Lemon explained that it was his license and said, "Excuse me, sir. Can I ask you something?" Thompson responded, "No." "Quiet. Calm down." Salazar Lemon said, "Okay." Thompson walked back to his car and ran Salazar Lemon's license, which came up clear, with no record of a criminal history. Although Salazar Lemon had consumed several drinks that evening, he was not drinking while driving and was not obviously inebriated. Still, Thompson summoned Salazar Lemon over to his car, then told him he was going to jail and attempted to handcuff him. What happened next is a matter of dispute. Salazar Lemon asserts that he pulled his hand back and started to walk away when Thompson yelled, "Stop," and fired his gun. Thompson insists that the 2 men engaged in a brief struggle and that when he told Salazar Lemon to stop walking, he reached toward his waistband, as if for a gun. Initially, Thompson said he pulled the trigger after Salazar Lemon reached toward his waistband. But several months after giving that statement, Thompson gave another statement in which he recalled that Salazar Lemon actually turned toward him as he reached for the gun that did not exist. It isn't clear why Thompson failed to include this critical detail in his first report. Regardless, a district court dismissed Salazar Lemon's lawsuit alleging a violation of his Fourth Amendment right to be free from excessive force. The court granted summary judgment to Thompson, depriving Salazar Lemon of the opportunity to present his case to a jury. Reviewing both men's affidavits, the court found that there was no genuine dispute as to any material fact. If Salazar Lemon had contested Thompson's claim that he reached toward his waistband, the court explained, the case would involve a factual dispute best settled by a jury. But because Salazar Lemon had not explicitly contested that particular claim, he never mentioned his waistband at all. The court concluded that he was not challenging Thompson's version of the facts. Therefore, Thompson was entitled to qualified immunity, a shield against Salazar Lemon's lawsuit. Courts have long held that officers may reasonably fear for their lives when a suspect reaches toward his waistband, meaning an officer who shoots an individual for doing so cannot usually be sued. The Fifth U.S. Circuit Court of Appeals affirmed the lower court's judgment, and on Monday, a majority of the Supreme Court voted to let that decision stand. As Sotomayor pointed out in her dissent, both of these rulings warp the law in an effort to reach a police protective outcome. Neglecting to mention reaching for his waistband was hardly the same as confirming it, she argued. Salazar-Lemon's own testimony contradicted Overt Thompson's claim that Salazar-Lemon had turned and reached for his waistband. According to Salazar-Lemon, Thompson fired his gun as he shouted "Stop." According to Thompson, he discharged the weapon only after Salazar-Lemon turned and reached down. In Salazar-Lemon's telling, this action, swiveling around while moving his hand toward his waist, did not occur. There is thus a factual dispute for a jury to resolve. Our failure to correct the error made by the courts below leaves in place a judgment that accepts the word of one party over the word of another, Sotomayor continued. It also continues a disturbing trend regarding the use of this court's resources, namely, that the court routinely intervenes to protect police officers from lawsuits but rarely intervenes where courts wrongly afford officers the benefit of qualified immunity. This trend, the justice noted, is especially distressing in light of the growing pattern of officers shooting men who are allegedly reaching for empty waistbands. To illustrate this point, Sotomayor cited a study showing that nearly half of the individuals shot by Los Angeles police after allegedly reaching for their waistbands turned out to be unarmed. She also cited an entire Washington Post article by Radley Balco collecting instances of what Balco calls unarmed man reaches for his waistband shootings. That these cases are increasingly common, the justice wrote, makes it even more important for lower courts confronted with such inconsistencies to let the jury exercise its role as the arbiter of credibility disputes. When Sotomayor writes a dissent like this, she frequently intends it to serve as an admonition to the broader public to pay careful attention to her colleague's dangerous error. Here, Sotomayor is clearly concerned about the judiciary's tendency to shield even the most violent officers from lawsuits. But she is also dismayed by the underlying problem in the case, the ease with which cops can justify shootings by alleging that their unarmed victims were reaching for guns. Officers have used this defense across the country, often after killing minority men. The courts, Sotomayor suggested on Monday, have become complicit in this injustice. And until judges stop favoring law enforcement's version of the truth, men like Salazar-Lemon will have little protection against the gruesome horrors of police brutality. One more thing. The Trump administration poses a unique threat to the rule of law. That's why Slate has stepped up our legal coverage, watchdogging Jeff Sessions' Justice Department, the Supreme Court, the crackdown on voting rights, and more. Our work is reaching more readers than ever, but online advertising revenues don't fully cover our costs, and we don't have print subscribers to help keep us afloat. So we need your help. If you think Slate's journalism matters, become a Slate Plus member. You'll get exclusive members-only content and a suite of great benefits, and you'll help secure Slate's future.
Hey Charlotte County, this is Charlotte County Cop Watch, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. but my wife would love it if some, if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave a, let's say, actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But, do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea, too, that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.